All right, here we go with Chapter 3. I always put a disclaimer on this particular lecture. I'm going to use examples. I hope I don't offend anybody by my examples, but these are real world or my experiences, I should say, or hypothetical situations that may involve any of the laws that we're talking about. Obviously, when we talk about equal employment opportunity and the laws, we talk about discrimination, we talk about harassment. Affirmative action, workforce diversity are the two other sections, but typically when you have a company that is following the law, hopefully you have a company that welcomes diversity. I want to start out by saying that all of the laws that pertain to equal employment opportunity, affirmative action, diversity, all of those areas, for the most part, are going to be tort laws. Tort law meaning it is civil law. It's not criminal law. When we talk about not paying people minimum wage, when we talk about not giving people overtime, violating OSHA, people getting hurt on the job, and the employer being willfully negligent in those areas, there are criminal penalties that are associated with that. There is a wage and hour enforcement division. OSHA has an enforcement division. The EEOC does not have an enforcement division. They have an investigation division. They don't go looking for issues. They don't do audits to make sure that you are not discriminating. They only respond to complaints, and they're basically a body that will investigate and join in that particular lawsuit, but you can't get fined by the EEOC. That doesn't happen. They don't have the ability to levy penalties. They only have the ability to investigate and to join in on a lawsuit if they feel that it has merit. Affirmative action is a little bit different because affirmative action has to do with government contractors. It might actually be a remedy that's put on somebody who's violated different laws. But affirmative action typically is going to refer to companies that have more than $50,000 annually in government contracts. And then finally, the issue of diversity, or the concept of diversity. I'm not necessarily going to dwell a lot on that. I think you guys can read through that in the book. I want to just cover certain areas, hopefully give you a better understanding, not only from an employee perspective, but really also from an employer perspective. As I said from the very beginning, that I really wanted to make sure that we had the type of dialogue, or at least I guess it's one side monologue. Unfortunately, normally I do this live, but normally, I want to make sure that you understand that should you open your own business, or should you become a manager, senior manager, somebody who's making policy, that you just understand where the rules of the road are. And hopefully if you get to be large enough and you have somebody like me, you can just know enough to say, okay, I need to ask my HR person, or I need to ask my attorney a question about that. It's really important that you do have somebody from an HR standpoint review your policies to make sure that you're not missing out on any pieces. There's a lot of affirmative defenses, and there's a lot of things that you can do as the employer to mitigate some of these issues. For example, with a harassment complaint, if you have a policy and you train on that policy and an employee does not follow that policy as far as reporting, that's actually, you can move for summary judgment on that. So there are some defenses, there are some things that have been set up by court cases where employers just need to understand where that is. That's why it's very, very important that you do have somebody that's an attorney that reviews your policies, that if you are going to take your policies from someplace else, make sure it's from a legal site, make sure it's from somebody who knows what they're talking about. Don't just try to write a policy statement by yourself, because you might miss something. All right, secret phrase. Secret phrase. I forgot to do this, so I had to go back and overwrite whatever's on this slide. So if it's a bad transition, I'm sorry. So secret phrase is go Gators. Or conversely, if you don't like the Gators, you can say, I can't say go Gators because I'm a Seminoles fan or USF Bulls fan or Miami Hurricanes fan or whatever, Georgia fan. I'm sure there's no Georgia fans. I hope there's not any Georgia fans. All right, that's all. Thanks. Put that one up. Answer the secret phrase, go Gators, or some reason why you can't. Thanks. The first one I'm going to talk about, and we could go back. I mean, I think the first civil rights law was 1866. There was President Truman who integrated the armed forces. There were some things that were happening, but really after Plessy versus Ferguson in 1896, from 1896 until the Civil Rights Act in 1964, discrimination was essentially the law of the land. It was perfectly legal to discriminate. It was perfectly legal to put a sign in your window that says whites only or men only or no Mexicans or no immigrants. And people did. And there are examples of a lot of that stuff. You can look at old pictures and things like that. In 1954, the Brown versus Board of Education of Topeka, Kansas came down, and that was a landmark case, which basically said Plessy versus Ferguson, separate but equal, that's no longer acceptable. That schools needed to integrate, that public accommodations needed to integrate, and it increased the consciousness of a lot of people. It basically changed a lot of thinking. Instead of saying, hey, the status quo is segregation, discrimination, now all of a sudden our constitutional rights apply to everybody. So the civil rights movement obviously got a huge boost at that point in time. I mean, there were other things that happened. A. Philip Randolph, who was involved with the Pullman strike and a few other things, was very involved in getting the armed forces desegregated. You know, in World War II, if you were African American in World War II, you could either be a porter or a cook. That was it. You were either like a room steward or you were a cook. There were no other options for you in the Navy. And that all changed in 1948 when we fought in the Korean War in 1950 to 53. The troops were integrated at that point. But really, Brown versus Board of Education changed a lot of things. Obviously, Rosa Parks refusing to give up her seat kind of got into the national consciousness, and there were a lot of protests. A lot of things were starting to change, but there was really no law that protected anyone. Obviously, when we talk about the civil rights movement, typically we're thinking about African Americans, but at the same time, there was Betty Friedan publishing The Feminine Mystique, and women's rights were starting to come to the forefront. We had Cesar Chavez, who was trying to increase the consciousness as far as migrant workers in California. And I mean, there were a lot of things that were changing. So 1964 landmark piece of legislation was passed, Title VII of the Civil Rights Act, which basically gave us the rights that we think we've had since 1776, but we've really only had these since 1964. And what it said was that we are no longer, as employers, allowed to discriminate against anyone based on race, creed, color, gender, national origin, and religion. Now, the Civil Rights Act covers a lot of stuff. It covers accommodations. It covers transportation. It covers just about every piece of daily life. It's like I said, it's landmark and it's all encompassing. But when we talk about employment, we're strictly talking about Title VII. So Title VII gives us some exceptions as the employer. And those exceptions are what's known as a BFOQ. So a BFOQ would be, for example, if I had to hire a locker room attendant for a gym, that being female, working in the female locker room would probably be a bona fide occupational qualification for that particular gym. If I had somebody who, let's say I needed a customer service rep that spoke Spanish, speaking Spanish is a bona fide occupational qualification. Now, I can't discriminate and say it's only people of Hispanic origin with that. Might be an acting role. We can think of a lot of different examples. Age is sometimes a BFOQ. Bona fide seniority systems. So if you have a seniority system and it tends to favor, let's say that you have an environment that has been majority male and there's more females that come in, that if you're doing everything based on seniority, then really somebody saying, hey, females aren't equally represented, say, well, we're doing this by a seniority system. And then professional tests. And it's very, very important that if you're doing selection tests or tests for advancement, that you make sure that those are validated, that there's no bias in those. And, sometimes when there are biases or there are issues with this, it can create some serious problems. So you need to make sure that you're testing for the right thing. And finally, it created the Equal Employment Opportunity Commission, the EEOC. So where we are with Title VII, now Title VII encompasses a lot of different things. When we look at what's going on right now with vaccinations, with hey, we're gonna mandate vaccinations. We're gonna mandate that. Well, Title VII of the Civil Rights Act says we can't discriminate on people based on their religion. And actually now we've got ADA. It's not part of Title VII, but let's just look at religion. So that's why there's a religious exemption to vaccinations, that if you have a religious reason why you don't get any vaccines, then it's up to the employer to accommodate that. Now, there are certain things that if it's going to be too costly for the employer, or it's just not something that they can do, it's going to be a safety issue to the employee or others. I mean, for example, if you had somebody who had to wear for example, somebody for religious reasons that has a beard. There are some religions where men are required to maintain a beard. There are certain regulations under OSHA for respirators where you can't have any facial hair. You have to shave that off. It's funny because I was talking to my dad yesterday, and my dad just turned 80 years old, and he told me, he says, I'm growing a beard. And I remember when I was a little kid, my dad had a beard or had a mustache, and he said, "Yeah, I had a mustache like 30 years or 50 years ago, but I had to shave that off because when I went into the clean room, I wasn't allowed to have any facial hair." So if it's in a situation like that, even if you have a religious exemption, if it's a safety issue, that safety issue is going to take favor over your religion. But the religion and ADA, it requires the employer to negotiate. Will this work? Will that work? You figure everything out with that. So Equal Pay Act of 1963. Equal Pay Act was amended again in 1972, and it says that men and women need to be paid the same amount. If the work requires the same skill, effort, and responsibility in the same working conditions, we can't just call it something different. It is very important that we allow opportunities, that we allow for advancement. We don't just classify something as someone as something different. So, for example, if you have a majority male position, let's be stereotypical, we have our janitorial staff that is majority male. We have our housekeeping staff, which is majority female. The housekeeping supervisor and the janitorial supervisor, if they're doing the exact same work, they need to be paid the same amount. So it's very important that you have different job factors. It's very important that you have things documented with the way that they need to be. Lilly Ledbetter Pay Act was passed in 2009. This is an example of fear-mongering and people wailing and gnashing of teeth. Lilly Ledbetter was supposed to completely change pay discrimination, because you can go all the way back to the beginning of discrimination. It's not just 18 months. So the time period was going to go back. So this was a landmark decision, and this is really amazing, and it really hasn't changed a whole lot. The bottom line is, really, as an employer, you need to be very, very careful. It's not an excuse for you to say, well, a female was willing to come in at $17 an hour and the male came in at $19 an hour. So 5 years later, there's a pay discrepancy because you've been given 5% pay increases. Now that gap is increased from $2 an hour to now $2.85. If they're doing substantially the same work at the same output at the same level, you need to at some point adjust that. And so this is the moment where I just kind of throw something out there anecdotally. I'm not saying that my experience is universal. However, I do see in my career that men are more likely than women to ask for more pay at the time of hire. And I don't know why that is. It's just something that I've observed over time. So I do encourage you that if you want more money, you can always ask for it. If you're ridiculous in what you want, you might lose the job offer. But if you're reasonable, they're going to say no. And even if they say no at that time, in the back of their mind, they're going to think, oh, Steve's going to want more money. So I need to remember that. His salary expectation coming in was $18.50, and I only paid him $17.50. So I better not give him a 25% raise. I better think about giving a 75-cent or a dollar raise to get him to where he thought he needed to be. So don't be afraid to ask. I mean, there are some companies, if you're working for the government, certain other very large employers where they have pay factors, and that's just, if you're in that pay factor, if you're an E6, all the E6 make the same amount of money if they have 1 year of experience, and then if you have more, you get more. Certain union environments, you don't have flexibility. But for most of our merit-based pay systems, and by merit-based pay, I mean they just pull a number out of their butt, because that's basically what most companies do. Let's face it, most companies don't have a system. They have an idea of what something should be paid. They know who their best performers are. They know who their worst performers are. And they're going to make decisions on who to pay what, not really scientifically. So I hope I haven't offended anybody by what I said about that. But it does tend to be true for your smaller employers. They really don't have a whole lot of science and facts behind why they pay what they pay. They just sort of pay what they pay. And even if some companies have salary ranges, we usually leave those pretty flexible, especially now with the job environment the way that it is. We've got to be very, very flexible because wages are going up, which is good news, which is really good news. We've seen significant increases, at least at the lower levels of wages, and over time that increases the higher level of wages. Because if you're bringing in somebody brand new and they're making $22 an hour, and you've got your star performer that's making $24 an hour, at some point that $22 an hour to start is going to impact your star performer at $24. So just keep that in mind. All right, next slide. Pregnancy Discrimination Act of 1978. Before 1978, it was perfectly legal to ask an employee, female employee, typically, if she's going to start a family. If I'm going to hire you, the last gal I hired, she just often got married and got pregnant, and then now I have to hire you. So I hope you don't do that. That's not legal. You can't ask that question. Also, the Pregnancy Discrimination Act said that you can't adjust your medical plan. I mean, there were medical plans actually that excluded pregnancy, which is kind of crazy. So you can't ask people questions on hire. We run into this issue sometimes that somebody is either pregnant or becomes pregnant right after being hired, and they don't reach FMLA. So FMLA, you got to be with a company for 1,250 hours and 1 year of employment, so you don't reach that. You just have to treat pregnancy the way that you treat everything else. I mean, if you have somebody that's, oh wow, this guy's really an all-star employee and he's really great, and he broke his thumb playing football and now he can't be a welder, so we're gonna give him we're going to give them a month and a half off for surgery and recovery. If you're doing that and then you tell somebody, if you're going off to have a kid, you're fired, you got to be careful. You can't treat pregnancy different than you do anything else. So unless you're willing to terminate anybody who's not able to come back if they're not access to FMLA, then really you got a problem. And we'll talk about FMLA in a later chapter. But FMLA, 50 employees within a 75-mile radius, you have to be 1,250 hours, and you also have to work for the company for a year, but you can't just enforce your rights under FMLA for one condition and not for another one. So you just have to be real careful on how you do that, especially if it relates to pregnancy. Civil Rights Act of 1991, a little bit more of a history lesson. In 1990, Thurgood Marshall retired. Now, Thurgood Marshall was the lead attorney for the NAACP. He also successfully argued the Brown versus Board of Education case in 1954 that I previously mentioned. And in 1967, President Lyndon Johnson nominated Thurgood Marshall to the Supreme Court. And he became the first African American on the Supreme Court, was the only African American on the Supreme Court. And when he stepped down, the president was George H.W. Bush. And there was I don't want to say groundswell, but there was pressure to replace the only African American justice with another African American. And he nominated a gentleman by the name of Clarence Thomas, who was ultimately confirmed and is actually still on the Supreme Court today, now some 30 plus years later, believe it or don't. So Clarence Thomas, in the hearings, they were asking him questions about a whole bunch of experiences and rulings and things that he did, but also they brought a witness that came forward, a woman by the name of Anita Hill, who alleged that while she was working for now Justice Thomas, then Judge Thomas, that she was sexually harassed. Now, the term sexual harassment didn't exist before this. Okay, I'm not sure exactly the terminology, but the consciousness and the understanding of sexual harassment really kind of came to the fore. It was the Me Too movement before the Me Too movement. And Anita Hill told some very credible stories of her treatment, about how she had been subject to comments, she had been subject to behavior that was completely inappropriate. A number of people heard that and pushed it aside, including our current president, by the way, who was a senator at that time. There are some folks that are on the left side of the Democratic Party that haven't forgiven Joe Biden for that. I'm not getting political here, guys. I'm just telling you history. So take that for what it's worth. But that was a big change for a lot of people, a lot of women. They saw what Anita Hill had said, and that's what they had gone through. That my mother went into the workforce when I started third grade, is when my mother went back to work. A lot of women went back to work. A lot of the baby boomers and a little bit older, they started to go back to work. Women weren't just staying in the home. They were going to work, and they were not just working until they got a husband. They were actually fighting for the same jobs that men had. And there was a lot of sexual harassment. There was a lot of discrimination. There were a lot of things that happened. There was no law against that. There was no law against you treating women terribly. There was no law against you being creepy or hanging nude pictures in your office or telling a dirty joke that was offensive to women. There was no law against telling an offensive joke about African Americans or about Hispanics or about Asians. You could do whatever you wanted. My parents used to have these joke sheets that would be passed around. This is before email, but they'd be photocopied. And there were all these really offensive jokes, and that was okay. It was completely acceptable. So workplaces, a lot of times, were very hostile to women and to minorities, that, it was a man's world. And they controlled you by making comments and by treating you a little bit differently. As long as they paid you as much as everybody else, and as long as they didn't fire you, then you had no other protection under the law. So women were fed up. There were a lot of other minorities that were fed up too and said, this isn't right. So the Civil Rights Act of 1991, for the first time, said, hey, if you're discriminating or you're harassing against somebody, then that's wrong, and you can't do that anymore. So it completely changed working. I remember comments that people made. I entered the workforce in 1985, and just comments that managers would make in restaurants and retail, all that stuff changed after the Civil Rights Act of 1991. And, people can rail about, political correctness. It was not really a good thing to be a woman or a minority in a lot of workplaces prior to this law. So it changed a whole lot of things. I said Lilly Ledbetter hasn't really changed a whole lot. This changed a whole lot for many, many employers. It also gave us the concept of disparate impact. So we have disparate treatment. When you treat people differently, when you don't hire or you fire people or you harass them in a certain way. I mean, that's what we would call disparate treatment. And disparate impact is a newer concept, and that's basically says, well, if we have a rule that says we don't hire anybody that lives more than 10 miles from the office. Well, if that particular rule has nothing to do with anything other than your opinion that somebody should only live 10 miles in the office, let's say that there are more minorities that live more than 10 miles from your office. Now all of a sudden it has discriminatory impact. It may not be that the rule was put in place deliberately to discriminate, but if you are discriminating against a group because of the rule, let's say that you have a rule that you have to lift 100 pounds. Well, if the only thing you're lifting that's 100 pounds is like one thing of copy paper, like once every 2 weeks, well, get somebody else to do it. It's not a job requirement. So if that requirement that you have is adversely impacting females, for example, then you need to take a look at that, and that's not a protection just to say, well, that's a rule. All right, Age Discrimination and Employment Act. My opinion, age discrimination is probably the last bastion of accepted discrimination. We call people old man. We ask people when they're going to retire. We make comments like, oh, well, we gave that person the job because they're younger and they have better computer experience. We make assumptions about people because they're older. When we do layoffs, they typically impact older workers. Age discrimination is real. I mean, 56% of people retire before they want to. Some of that's for health reasons, but a lot of that is because people get laid off. So there's another thing, too, is it says you're over 40, but somebody that's like, I'm 52, I could discriminate against somebody who's 68. Or if we let somebody go, typically as a good defense, let's say that you have an employee that's in a group that is causing lots of problems. And that person happens to be an immigrant from Slovakia. Half of me came from Slovakia, so there you go. That's why I came up with that one. So you're an immigrant from Slovakia, and you're causing all sorts of trouble. And you are being disruptive, and you're doing everything else. And they terminate you. And you're replaced by another immigrant from Slovakia. It's really difficult for you to make the case that the reason for termination was your immigration status, because they hired somebody who's exactly like you. So it's really difficult. And I'm not saying that, hey, if you want to fire somebody for a bad reason, then just hire somebody that looks like them. That's probably not a good idea. But it is a pretty good defense. If somebody says, hey, I was terminated because I'm female, or, we talk about reverse discrimination. Somebody says, well, I was fired because I'm a white male. Well, if 62% of the management staff is white males, it's kind of hard to make a case that being white male is a bad thing in your organization. So we sort of talk about that. But with the age discrimination, you can't fire somebody that's 68 and replace them with somebody that's 52. It's not a defense. Now, I mean, if it's somebody that's 60 and you replace them with somebody that's 59, okay, that's probably make it difficult for them to make the case. But keep in mind, these are all tort cases. These are all going to be decided. Typically, they're going to be decided in mediation. But if they did actually go to trial, I mean, you got to prove your case. So you got to have evidence of it. Somebody's probably not going to take the case if they don't think that anything is valid on that. When you do that, but you have to have 20 or more employers. Most of your employment law, there is an employer requirement. I think the EEO or the Title VII, I think it's a requirement. I think it's 10 employees. ADA is 15 employees. FMLA is 50 employees. And for the ADEA, it's 20 employees. So if you've got 5 employees and you let one of them go that's 71, they can't sue you under ADEA. You would file for summary judgment. We're not covered by the law. See you later. But in order for you to make a case, it's a 3-prong. Number 1, you have to have a protection under the law. Number 2, you have to have something bad that happened to you. And then you have to have a causal relationship. So those are the three things to make any cases under any of the laws that we're talking about. So, for example, something bad happens to you, you got fired. And then you have some sort of protection under the law. Well, we all have protections under the law, but it's hard to prove a causal relationship with that. I mean, we all have a race, creed, color, gender, national origin, religion. You just have to figure that out. And that's why it's really, really important that we as employers, we don't make dumb comments, and we don't make things look like they are. Because in front of a jury, it's kind of hard when you're the employer. I say that, but I've never actually had to argue an EEO case in court. I've only ever been to mediation. So that is a good thing. I don't ever want to do that. So Rehabilitation Act of 1973 was the first ruling that protected people with disabilities in the workplace. A lot of times what happens is that because the executive branch can have authority over the government, they usually will pass things for the government or government contractors. So the vaccine mandate was already put in place for for government and government contractors. President Biden can do that, but to affect private employers, there's a process that he has to go through. So he's asked OSHA to implement that. But if you just pass some government contracts, you can tell them to do whatever you want. Typically, it's going to be $50,000 or more for all this stuff, affirmative action and for Rehabilitation Act. Any of those types of laws are the way they're put in compliance. VEVRA has to do with discrimination against Vietnam vets at the end of the Vietnam War, or while the Vietnam War was going on, because the war ended in 75 and this is 1974. By the way, I read a lot of history, so if I'm boring you with dates or whatever, it's not, I don't know, it's just, whatever. But like, people are like, it's like there was a Saturday Night Live. Do I have to remember dates? No, you don't have to remember when the Vietnam War ended or any of that other stuff. I'm just trying to give you context. So the Vietnam War was not a very popular war, as you may be aware of, and there was a lot of backlash to the returning vets. So they passed a law that just basically said that you, as the employer, you need to do a good faith effort to try to bring in returning veterans to give them jobs, that you can't discriminate against them. You're also required to report on your Vets 100 report how many people have applied that were veterans, how many of those did you hire. It's since been expanded to include basically every other war that's happened, whether that's the Gulf War or the Afghanistan and Iraq. I don't know, Bosnia. Where else have we been to war? Somalia. But all that is included now in that. But the ADA was the last major piece of legislation. I mean, there's been certain amendments, but 1990 was it was a sweeping piece of legislation. Similar to Civil Rights Act, there's a number of areas that do not include employment. With the ADA, there's also access to buildings. There's also information that has to do with even like computer stuff, how your website is your website ADA compliant. So we need to make a good faith effort to make sure that qualified individuals with disabilities are able to work for us with or without an accommodation, that we have that requirement. So somebody comes in and they have a hearing issue, if somebody comes in and they have a mobility issue, it is up to you as the employer to try to accommodate that. Similar to what we talked about with religion, negotiation is the key. But you can't just fire somebody, not hire them, or demote them, or change anything for them because of their disability. And we really have to be careful that we treat all disabilities the same way. So, for example, if you have an employee that has a mental issue or a substance abuse issue, and they ask to take time off to take care of that, you can't just say, nope, can't work here, I don't want to deal with that. but you allowed somebody who was going to have a baby, or you allowed somebody who had a sprained ankle and had mobility issues temporarily, you allow them to do it. So we have to be careful that we don't discriminate based on their particular disability. We do not have to accommodate somebody who's not able to perform the essential functions of the job, meaning we don't have to write a new job description for them. However, we have to be careful that the information that's in our job description is actually the essential functions and duties of their position. So if there's a requirement that, or a practice that the receptionist always picks up donuts on Friday, and there's a candidate that's going to be hired that has some sort of condition where they're unable to drive a vehicle, we can't say, oh, well, driving is a requirement of the job because you're the one that picks up the donuts. Somebody else can pick up the donuts. It shouldn't be a requirement. So when ADA was passed, it was this fanfare and this great thing. Isn't this wonderful? When that was passed, the idea was, oh, okay, well, everything's going to change. And I mean, it did. It changed a lot of employers. It changed access. It definitely changed our thinking. You know, people put in policies. They put in diversity programs. They did a lot of really good stuff. The problem is that people were filing suit and they weren't winning. In fact, nobody won a single ADA case from the enactment in 1990 until, I don't know, whenever it was, 2006, 2007, when this legislation was proposed. And the reason for that was because disability was defined as anything that limited a major life function. And the problem with that is defining life function. So they expanded it to say life function. And it basically gave more areas where people could be covered. So basically anything that ends in an ing, you know, walking, standing, stooping, bending, lifting, all of those areas might be accommodated if you have a disability. So it put a little bit more of a burden on employers to provide those disabilities to people who've requested them. IRCA, back in 1986, we had an issue with immigration. We had a lot of illegal immigrants in the country, and there was also a pressure, too, because a great number of them were working in agriculture and working in other types of positions, and there was not really a desire for us to just immediately deport everybody that was illegal. So the Immigration Reform and Control Act was passed, which created the I-9, which we all fill out. That was created because of this act. Before that, you could do whatever you wanted. In fact, before that, I had a forged birth certificate so I could say I was 16 so I could work more hours at McDonald's. I think the statute of limitations has run out. That was 36 years ago, so I think I'm good. But I made myself 6 months older so I could start working at quote-unquote 16, which got really awkward when they wished me a happy birthday and gave me a cake in April when my birthday was actually in October. But I digress. So that law was actually passed the year after that, and then I had to fill out an I-9. But after that, I was gone. I'd left my job at McDonald's and gone to the record store, so life was good. But it did several things. So, like I said, it created the I-9, but it also said that you can't discriminate against people based on their citizenship. So if somebody's legally able to work in the United States, you can't discriminate. You can't say citizens only. That is not acceptable. That is not allowed. So there you have it. All right. USERRA. We don't run into USERRA very often. I've actually, in my 20 plus years in HR, I've run into it twice. If somebody's in the National Guard and they're called up for active duty, there's a requirement you have to keep their job open. So you have to rehire them when they come back. There's also what's known as the escalation clause. And we currently have somebody who's serving in active military, was called up from the National Guard, is now active. And we give him a pay increase every time that it's time. He was in the apprenticeship program, and he should have been receiving raises as he went along. So we just give him 50 cents. He's going to come back and he's going to be making $250 more than he would have. So we're going to do that, and then also do what we can to return him to that position. It's just important that you understand the law exists. Again, you're not going to run into it very much. Where you do run into it, I said I only ran into it twice as far as people called up. But where you do run into this is somebody says, "Hey, I have National Guard duty, my yearly 2 weeks that they have to do." You can't say, "Well, you're going to have to take PTO," or I can't give you that 2 weeks. You've already taken whatever. You can't use that against them. So their service can't be used against them whatsoever. GINA, we don't really run into GINA very much. I mean, this is I said the ADA was the most important piece. This is a minor piece. Really, we don't see it very much. I mean, I guess if you had a genetic test, you can't use that to charge somebody more for their medical insurance. I mean, that would not be that protected that. So if you said, "Hey, we're going to take a swab of your mouth, and then we're going to do genetic testing, and we're going to find out if you're susceptible to any diseases, and we're going to charge you any differently." Really, kind of the Affordable Care Act probably made sure that you couldn't do that because you can't discriminate on anything with the Affordable Care Act. So I think that stuff all changed. But you can't make employment decisions based on that. I don't know. I mean, how many people are going to be like, Law and Order, like, "Oh, we just got a coffee cup out of the trash, so we're going to test their DNA to figure that out." I mean, this all seemed in 2008 when I was reading about it and it was passed. I was like, this is like sci-fi stuff, but maybe we need to protect against it. But here we are 12, 13 years later, and it really is not an issue. I mean, I can't think of too many ways unless you're a huge employer. I mean, I don't know, maybe an Amazon or somebody like that. Yeah, maybe they would discriminate based on that if they could. But yeah, just kind of interesting. Like I said, it was like Star Trek stuff. So state and local laws. The most important thing to look at with this is that wherever it is most favorable to the employee, that's the law that prevails. So there are certain laws, anti-discrimination laws that are local laws. They might have some city laws about, sexual orientation or equal pay or anything like that. I did want to mention, too, sexual orientation, because actually when this book was published, the Supreme Court case had not come down, but for the longest time, sexual orientation was not covered under any of the laws. Interestingly enough, I mean, obviously there were local and state laws in California, but California, even before that, had interpreted, they had more liberal justices out there, but typically as California goes, so goes the rest of the states. But California had interpreted that discriminating based on sexuality or sexual orientation actually is gender discrimination. They kind of stretched that out, made the argument, but it's actually kind of brilliant and sound legal strategy if you ask me. But they said, hey, if you're a woman who's dating a woman, then I'm treated differently than if I'm a man dating a woman. The only thing different is that I'm a woman, so therefore it's gender discrimination. So kind of a novel idea, but actually sort of worked through. But that's sort of moot right now because the courts have ruled and said that you can't discriminate based on sexual orientation. But if you do have state and local laws that do protect employees a little bit more, you do have to follow those. It is very important when you go into certain states, and it's mostly going to be in the blue states. So if you're going to New York or Illinois or Colorado or California, it's very important that you know what the state and local laws are there. You can't just say, well, I'm a Florida employer. As soon as you have an employee in California, that employee is bound by California labor law. Typically if you stay in the Southeast, we operate mostly in Florida, Alabama, Georgia, North Carolina, South Carolina, into Virginia. There's really not a whole lot of things we have to think about. But when we do have employees that are out in California working, we just have to be careful that we understand what those laws are. And there are also different laws that impact pay. For example, holiday pay and overtime pay. I think California and Colorado, it's more than 8 hours in a day unless you're working 410s, and that's published. But anything more than 8 in a day, you have to pay overtime. By the way, Florida doesn't really have any laws. They've got some child labor laws that are specific to Florida, but for the most part, we are not. We're not real progressive with employment law. Most of your southern states really aren't. Just sort of that's the way that it's kind of set up, and really it makes it easier to perform HR law in Florida because there's less stuff you have to deal with. But when you're an employee, it's not really good because there are certain areas, for example, wage and hour issues and other stuff where, obviously as an employee, I think we would much rather have more protection. So that's just, again, not political commentary, just stating the facts. So the EEOC is responsible, obviously, for private employers, for public employers, or for employers that deal with the government for certain issues like the Rehabilitation Act, some of the affirmative action executive orders. That's going to be responsible by the OFCCP. The employers themselves are obviously, they need to police themselves. Ignorance is no excuse when somebody brings a case. So the process in handling a discrimination case, anybody that comes forward, anybody at all can file a charge against an employer. All you have to do is you go online and you file a charge. This is what happened. I've been discriminated against. You have to indicate what law was violated. For a tort, you have to have protection under the law. You have to have something bad that happened to you, and you have to establish a causal relationship. So you put that in there. So you put that information in there. The EEOC doesn't review your charge. All they do is forward it along to the employer. The employer responds to the charge, and then a mediation is set. Most cases are going to be solved at mediation. Most cases do not go to trial. They don't go beyond that. There's only one case that we've had that's gone beyond that, and I actually was recording the audio for this, and I started telling that story, and I said, I probably shouldn't do that because if that individual heard this, I don't know what they would do. But so I'm not going to tell that story. But at any rate, it was a very frivolous case, and we did not settle anything because he was demanding a ridiculous amount of money. And we had to do the investigation with the EEOC. We had to send them all the information. We had a pretty rock-solid case. The EEOC issued a no probable cause and gave him 90-day right to sue. So with that, you jump out of that process. If there's probable cause, then you go to that next step. You go to a second-round attempted conciliation. Now you're in pretty big trouble. At that point, if you're the employer, if the EEOC is going to join that, initiates the actions, and then you move on from there. Usually, you're going to settle your nuisance cases for between $5,000 and $15,000 because when you take it to the next level, do you really want to be investigated by the EEOC? Do you really want to have to deal with that, or do you want to just move on with your business? Your legal fees are going to become much more expensive because now you're going to have to subpoena witnesses. You're going to have to interview those witnesses. You're going to have to do all sorts of work and legwork, and that legwork gets really, really expensive. I mean, just negotiating and trying to get something done, it's going to cost you a whole ton of money. So it is very important that you do get those things resolved, even for a nuisance amount. One of the things to do as the employer is, if you have a touchy situation, if you have an employee who's claimed discrimination in the past and now you're going to fire them for performance, you probably want to get them to sign a release of claims and give them a financial settlement, and a generous financial settlement. Now, you have to be careful that you have a somewhat uniform policy on how you do these generous settlements, because you're sort of admitting guilt, right? If you're all of a sudden paying the person, a female who claims that she's been sexually harassed, when she gets fired, she's offered $10,000. Well, the company usually only offers $1,000 severance. So now all of a sudden we're saying, hey, that might be something that might give the impression, if it were to go before a jury, that we are somehow discriminating or treating her differently because of her gender, because of her claim. So you have to be careful of that. But your release of claims that you get, make sure that you have an attorney that draws that up. Don't try to do that one on your own. but it is a nice thing to have in the HR toolkit. So uniform guidelines on selection procedures basically helps people to understand. So you can research the uniform guidelines to make sure that you are doing things the right way. That the EEOC and Department of Labor have come out with a lot of different areas that can help us as employers how to do things, whether that's going to be OSHA, whether that's going to be EEO laws. And it helps you to comply. As I mentioned before, with harassment, if you have a harassment policy, if you train your employees on the harassment policy, and you have an outlet for them to independently go to HR or whoever that is, if they don't do that, you can remove what's known as vicarious liability. So the concept of vicarious liability means that your managers act in the place of the company. So I mentioned with discrimination, with the Civil Rights Act of 1991, that it created the concept, or actually codified the concept of adverse impact. The two types of discrimination are certainly disparate treatment or intentional discrimination, where we specifically do something. Somebody says, hey, we don't hire people like that, or they make a crude or snide remark about a gender, and they go through that, or they, something, for example, oh, well, he's a man and men are the breadwinners of the family, so he needs to make more than her. That's discrimination. I mean, that's just intentional discrimination. You can't couch that any other way. But disparate impact, again, it's unintentional discrimination. Usually we're not going to be doing anything on purpose, but there are certain circumstances, there are certain situations that, let's say that you don't take any mailed in resumes. You only take emailed resumes. Well, that's something that could potentially impact certain people if they don't have access to a computer on a regular basis, or requiring that employees have a car. We need to require that they show up to work on time, but just because you don't have a car, you can't discriminate, because that might be something that whether it's race or ethnicity or possibly age, you might be discriminating against people based on something that really has nothing to do with employment. So when we look at adverse impact or disparate impact, we are looking at what's known as the 80% rule. So when we look at adverse impact, we look at an area, let's say that during 2017, we have 300 and 300 that were hired. If we have a larger number of applicants that are African American, that are Caucasian, and keep in mind, these are qualified. There is nothing in the rule that says that you need to hire unqualified applicants. You don't have to do that. You don't have to change your job description based on race, creed, color, gender, national origin, age, religion, disability, any of those things. You don't have to change that. The only thing you have to do is you have to consider applicants regardless of who they are. If they've got a name that's hard for you to pronounce, you can't just say, well, we're not going to hire that person. That's our requirements. So as long as they're qualified, who cares? So when you look at this situation, if they are truly qualified, even though we've hired them in equal numbers, we have far more. We've got 50% more applicants that are African American. We're probably discriminating. That we should more than likely have 400 to 200 or 350 to 250, something like that. I can't do all that math right now. So affirmative action it only applies to government contractors. So if you're doing $50,000 or more in government contracts in a year, then you are required to participate in affirmative action. So affirmative action is just what it sounds like, just affirmative action. You're not required to hire a certain number of people. You're only required to take steps to ensure that you are representing the area in which you serve. So if you are in a certain area where people tend to be Hispanic, you need to try to make sure that you recruit a workforce that looks like your surrounding area. And if that means that you need to have bilingual managers, if that means that you need to do more community outreach and advertise in areas and in ways that might reach them, then that's what you need to do. That if you look at the area that says, okay, well, our workforce is our qualified workforce is 50% female and 50% male, yet we only have 10% female. What are you going to do to try to attract more female employees? That's what you're required to do with affirmative action. You need to make a good faith effort to try to get employees in proportion to representation in the labor market. And that's qualified employees. That's employees who want to work for you. If you work in construction, obviously it's typically more males than females in construction. But if you're following affirmative action, actually, if you're following anything, you can't just say, you know what, we don't hire women because women don't usually make it in construction. You can't do that, especially if you're covered under affirmative action. But you do need to have a plan, and you do need to track that. This has been around since 1967. With Executive Order 11246. Affirmative action does not mean quotas. And I think people think that that's what it means. It does not mean quotas. It doesn't mean that you have to make sure that you hire people at a certain level and then you're done. Because quotas are like, it's target. Okay, I hit my quota. I don't have to hire anymore. No, you're creating an environment that is more attractive to the groups that you're targeting. So we look at underutilization analysis. And this is an example here of that. If we're looking at availability for certain jobs at 30%, the organization should try to make a good faith effort to get to 30%. If it is less than 30%, what are we going to do to fix it? So uniform guidelines on sexual harassment. We have two areas with sexual harassment. One is what most people think of as quid pro quo. I'm offering you, quid pro quo being Latin for this, for that. I'm offering you something in exchange for sexual favors, or if you don't give in to my sexual favors, I'm going to take adverse action against you, that I'm threatening you in some way. That's quid pro quo. And then hostile work environment. And really, it's not even just sexual harassment, it's any harassment based on protected status. That if we're creating a hostile work environment, we're creating an environment where it's not comfortable for somebody to work there because of our comments, because of our actions, because of the way things are done. There is a concept that's called constructive discharge, that if somebody goes to HR, goes to their manager, they've been treated horribly, and they don't resolve it. They say, just, you're lucky to have a job, go back to work. If you resign, because the only way you can end that harassing situation is by resigning, it's known as constructive discharge. And in the law, it is the same as if you fired that person. So just because somebody quit, it was like, oh, they quit. Well, we're fine. We're good. No, maybe you're not. So keep that in mind. So national origin discrimination, that we need to make sure that, we are careful with that. I think, I mentioned about age, people do make jokes and they do make comments. I think sometimes with national origin, people do make certain comments about different things, especially, I think, after, obviously yesterday was 9/11 anniversary and there was a lot of comments and a lot of things that were made about people who may have been from Middle Eastern countries or Northern Africa, any of those types of areas that were kind of affected by or had people from different area. I think Egypt and Saudi Arabia and a few others. There was actually comments and things and situations that happened about Sikhs that are from India and have absolutely nothing to do with Islam, completely different religion, and they were treated differently because of wearing turbans. And we have to be real careful that we don't lead into that. We don't make an environment where we can sort of tease people about that. I mean, I think there's a lot of the political correctness or whatever. I mean, there are certain things that kind of go over a line, and I'm a white guy. I've worked in different places and different things and done whatever. So I can't even imagine what other people's working experiences have been. But there have been certain situations where I felt like there were things that were said that I couldn't speak up about. I just had to like laugh or do whatever. Not that I'm equating it to anything, but there were times in my life where I was very heavy. I was approaching 300 pounds. I was a bigger guy. I was pretty sensitive about it. Didn't really like that, but people would make, hey, a big guy. I was like, oh, watch that. Don't sit in that chair. Comments like that, and people would laugh about it. And you're in the workplace. You don't want to act like you're sensitive or do whatever. So you kind of have to sit there and take it. A little bit. That's the only experience, and obviously that's not probably the same experience as other people have gone through. But when people are making comments and are doing things, it is important that we as management, we are sensitive to that and we are aware of that, and we do tell people to knock it off. I think especially if you're in the majority, you want to get along. You don't want to bring that up. It's like, oh, we're just joking around. You don't want to be the person that says things, but some of those things, knock it off. We don't really need to be making a lot of those comments, and it's not really pertaining to national origin, but a situation with somebody that worked at my last company that he was born deaf, and apparently there was an operation and he got his hearing back when he was like 3 or 4 years old. Well, because of his experience of not being able to hear, as he got speech and he started going through a lot of that process, he spoke and sounded like a little bit slurred when he spoke, and the guys would call him dummy. And he just let it happen until finally he'd had enough. And it'd been like 8 months. He came to my office like, man, I quit. I can't deal with this stuff. And it's like, well, what if we fix that for you? What if we get that done? And we did, and had conversations and got that sort of fixed for him. But his manager, we called the manager on the carpet. It's like, you can't do that. You can't allow people to do any of those things. So just something to be aware of with that. Management takes courage, and it takes courage to tell people not to do certain things, and you have to do it. You have to have that courage. Final thing on here is English. Actually, back to this too, discrimination. Being careful as far as how you're evaluating people, what college they went to, or what kind of name do they have. Or what other things are on their resume. I mean, we can't just deny somebody employment because they went to the University of, I don't know, Budapest in Hungary, and it's like, oh, they didn't go to an American college, therefore they're not as smart as we are. That is national origin discrimination. We can't do that. English only rules, if they are for safety reasons or for customers, that's fine. But we can't tell employees how to communicate with each other. We also can't tell them what to do on their break. Just because somebody doesn't feel comfortable because they're talking Spanish and they get paranoid and they think that somebody's talking about them, or they're speaking Creole or French or whatever, we can't just say, oh, English only, can only speak English. You can only do that, like I said, for safety reasons and for customer preference reasons. Final thing is religion. As I said before, we are required as employers to have a certain degree of discussion, and also to try to accommodate, to give people recommendations or ask them for recommendations for us. One of the things that we run into on a not a regular basis, but a semi-regular basis, is the people that are on call. If they're on call on the weekends and they're Seventh-day Adventists, Seventh-day Adventists, they rest on Saturdays. So if Saturday work is required, if that's absolutely required, ironclad, then we don't have to. I don't want to say we don't have to, but we're unable to accommodate that. Let's just say that we're hiring for a position that absolutely has to work on Saturdays, no question. Then we can't accommodate that. But for on-call pay or on-call work, what we've been able to do is say, okay, well, we'll exchange Saturdays for certain holidays or certain nights of the week. We can accommodate that if we can spread that out. Now, we had a situation in a very small office where we only had 3 employees that covered that office, and somebody was applying for an internal transfer, and they said, hey, I'd like to move over to that position. And we said, well, unfortunately, there's not enough people to spread around the on-call, so we would not be able to accommodate in that particular office. So I guess he consulted with his pastor and came back to us and said, well, here's what my pastor said, that if it's an emergency, it's God's work, and if you're scheduling work, it's not. So I am fully prepared to work for an emergency, but I will not do regularly scheduled work. And we said, we can accommodate that. That's fine. So that's a perfect example of how you accommodate based on religion. So religion and disability are the two areas that we work to accommodate. All right, I've gone for over an hour. This is probably the longest area that I have. Hopefully you have been enlightened by my representative examples, and I have not given you an example that you took offense to. Hopefully you didn't, but I know these are sensitive areas, and it is up to us, like I said, as the employer, to be the responsible one, to tell our people when they step out of line, to create an environment really that's welcoming to everybody. That is very, very important. Because like I said before, people are sometimes afraid to speak up. They're afraid to speak up when they see injustice, whether it's done to themselves or done to somebody else. So having the courage to do the right thing as managers can sometimes really not only improve the lives of your employees, but keep you out of court, which is something that nobody ever wants to deal with. If you have any questions about anything that I've covered here, any personal stories or questions about is this discrimination or is this not, please let me know. Keep in mind there are a lot of things that happen in employment that are not fair, but not fair doesn't mean illegal. So I can fire somebody and then hire my brother to replace them. That's not fair, but it's not illegal. I can hire my friends and promote my friends. Unless my friends are situated differently than you are, then, nepotism and favoritism, those are not illegal things. Unless the nepotism and favoritism obviously are favoring males over females or favoring people of certain ethnicity or race or whatever. So that's about it. Thank you, everybody, for listening. And I will be posting 5 and 6. I don't usually do a lecture for 4. This is usually my longest one because there's a lot of stuff to cover and stories to tell. So thank you very much. Have a great week.